One statement we often hear is this: "We weren't married, so I don't have any rights, do I?" And for many people, that belief stops them from doing anything at all. The truth is, being unmarried does not automatically mean you're excluded from making an inheritance claim. In fact, many successful inheritance claims in England and Wales are brought by people who never married their partner. So let's talk about how this actually works. If you weren't married or in a civil partnership, you won't inherit automatically under the rules of intestacy. That can come as a shock, especially if you shared a home, shared finances, and lived like a married couple for years. But that isn't the end of the story. Under the Inheritance Act, you may be able to bring a claim if you were financially dependent on the person who died, or if you lived together as a couple for at least 2 years immediately before their death. Here's a real example we see all the time. A couple lived together for 10 or 15 years. The house is in only one name. The will is outdated or doesn't exist at all. When one partner dies, the estate passes to adult children or distant relatives, and the surviving partner is suddenly worried about keeping a roof over their head. The law does recognize that situation. The court looks at the reality of the relationship, not just the legal status. It asks questions like, were you living together as a couple? Did you share bills? Were you financially reliant on each other? And what provision has been made for you now? Another example might be a partner who gave up work to care for the deceased during illness. After the death, they are left with nothing because they were never married. That kind of financial dependence is exactly what the court will consider when deciding whether reasonable financial provision should be made. It's important to understand that inheritance claims for unmarried partners are usually about meeting needs, not receiving an equal share of the estate. The court's focus is on fairness and financial security rather than entitlement. Timing is absolutely critical. In most cases, you only have 6 months from the date probate is granted to bring a claim. Many people come to us after that deadline, believing they had no rights, only to find the door may already be closing. There's also a lot of confusion around wills. Even if the will leaves everything to someone else, that does not automatically prevent a claim. A will can be legally valid and still fail to make reasonable financial provision for a long-term partner. Inheritance disputes are rarely just about money. They're about stability, fairness, and recognizing the life that was built together. At Blackstone Solicitors, we regularly advise unmarried partners who assumed they had no options, only to discover they do. Getting clear advice early can make all the difference, especially before deadlines pass or estates are distributed. If you weren't married but feel you've been left in a difficult position after a partner's death, it's worth understanding where you stand. The law may be more on your side than you think.